Welcome to Prison Professors. I am Michael Santos, and today I am really enthusiastic to introduce you to my friend, Kyle Singhal. He is a partner in the Washington, D.C. law firm of Hopwood Singhal, and he's going to tell us a little bit about his journey to becoming an attorney, the areas of practice that he specializes in, and we're just going to learn a little bit more about what steps we should be thinking about if we're coming into the criminal justice system, or if we really don't like the outcome that we have. So Kyle, thanks so much for taking time out of your busy schedule to spend time with our audience. Could you tell us a little bit about what it was that got you excited about studying law?
Yeah, thanks for having me, Michael. Happy to be here and to be a part of your programming. I'll give you a two-part answer to that. First is what got me to law school, I suppose, and then what got me to being a lawyer. I must have told 100 people or more when I was in law school that, I'm not going to actually be a lawyer. I just wanted to see what law school was like. And then, sure enough, many years down the road, I loved practicing law. But what got me into law school in the first place, I just happened to be tutoring people for the test that gets you into law school. I was teaching a number of these tests. And so the law school admission test was just kind of fun. I enjoyed the puzzles and arguments that it had on it. And I tutored folks for about 2 years before I decided to go to law school myself. And so law school won out over the other options. At the time, I was thinking about business school and other things because I had sent numerous good people off to law school. And I also happened to be working for a great lawyer in Texas who had a little shop, and I learned a lot about how the law worked there. And I would have to mention, although he wasn't a direct influence, there's a third source, which is my uncle, Rag Singhal, is now a federal judge and was then a state judge in Florida. I think in the back of my mind, since childhood, I knew that he was this great lawyer. He had a very prominent career as a criminal defense attorney before he became a judge. And so all those sources together probably played some role in my decision to go to law school. But once I got there, I just thought I would keep running my little tutoring shop and do that until I participated in the law school experience. And it was really the experiences I had in law school that sold me on a career in the practice of law.
So that's really interesting, and I think it's important for me to point out, as you and I have discussed, but some people on our YouTube channel don't know this. One of the missions of Prison Professors is to teach and inspire people who are serving time in prison. And you just gave me an idea that I'd like that people in prison to consider. You said that you'd built a career teaching other people how to take tests.
Yes.
And I know that's a big industry out here because people are going to invest time in building a career, and their ability to score well on a test really influences their ability to get into the right law schools. And I hope I'm not going to be prying, but if it's not an inappropriate question, could you tell us a little bit about the market for that? Because somebody doesn't have to be a lawyer, as you just described, to teach somebody how to score well on a test. So if somebody's serving a 10-year sentence in prison, they could invest 10,000 hours to master tests and then build a business teaching people how to take tests. What is the market for a business like that?
It's pretty good. And I think that would be such a fabulous direction for someone to go in. If someone were to get out of prison and take the test and score well, it's quite feasible that they could earn $100 an hour or more. Of course, they would need to both score well on the test and be a good teacher. Just because, for example, someone speaks English doesn't mean they can teach it. Likewise, like you said, they'd have to spend really that 10,000 hours mastering the test and how to teach it. But it's not uncommon for someone to make $100, $200, or even $300 an hour after they've had some thousands of hours teaching the test. So it's a good market. It's not saturated yet with tutors. I still get calls all the time that I can't handle, and I really don't have good people in Washington to refer them to. I've got people elsewhere, but people, are still looking for a personal connection, someone they can see in person as opposed to do it online. And so that's something that I don't think the market's going to go away for, even if the test is online. People like to have an in-person teacher.
There's no shortage of income opportunities, there's really just a shortage of ideas. And if you're sitting inside of a jail or a prison, or you're going into the system and you're worried about how you're going to earn an income, you've just got to keep your eyes open. And we just heard a phenomenal idea from something that Kyle did before he was a lawyer that anybody can do if you are willing to put in the work. Now, Kyle, I know that you're not teaching tests anymore. You're a very successful attorney that has a unique specialty, and you're partners with our former co-founder, Shon Hopwood of Prison Professors. Tell us a little bit about how you met Shon and why you guys started working together.
Well, I'll tell you, I do still teach a little bit aside from the legal practice, Michael. I do a little bit of LSAT just for referrals if there's a need. I do a little bit of bar exam tutoring, but that's almost entirely for folks who are retaking the exam. So if someone has failed the bar exam and they need a second try, I do a little bit of that. And I do some law teaching. And so, for example, I have co-taught a course on constitutional law at the University of Louisville Law School. And I teach a bar exam support class at the George Washington University School of Law as well, which is where I went to law school. So I do a fair bit of ancillary teaching on the side still.
Let me ask you a question on that subject before we get to your partnership with Shon. How do you market that type of work? Because yesterday I did a video for people in prison teaching them how I market, what I do, the brochures that I create, the websites that I create, the campaigns that I create. Maybe you could help us understand, if somebody wanted to hire you, how would they find you? Is it word of mouth or you do work?
I have been almost too fortunate in that that work comes to me. It's been all word of mouth. I haven't had to do any marketing for LSAT, bar exam, or this ancillary teaching really in 8 or 9 years. So I always get more calls than I can handle, and I try to allocate my time in whatever manner is going to produce the best results for the most people. I think maybe that's not even the right way to say it. I prefer to work with fewer clients the more if I can help someone to solve a big problem, whether that's a legal problem or something else. I enjoy solving big, hard problems, not necessarily more problems, but I think I get calls for one thing or another at least every week, if not every day. And the challenge is figuring out what to say no to. And I think once you've established yourself in any field, and this is especially for those who are looking to establish themselves, pick 2 or 3 ventures and once you get and figure out what you like and what you're the best at and what you can do the most good with. And once you're busy enough with that, then you can let the other sources of income go.
I think that's great advice, and I really appreciate you dispensing it. We're going to be more than 100,000 people get to watch this program inside of jails and prisons, and I think that they'll get inspired by that message. But the salient point, the real key point, is you've got to invest the time and the energy. And if you're in a jail or a prison, you could always be developing your skill set with regard to how well you can string words and sentences together and turn them into paragraphs and into pages, and then develop your critical thinking skills. And that's what Kyle's partner, Shon, did so well. And we'll feature him on this program, that while Shon was in prison, he became an expert in the law. And when did you two start working together, and how did you guys meet?
Yeah, well, so we met, we'll start with, since that came first, when he was coming to Washington to clerk on the D.C. Circuit Court of Appeals for Judge Brown. And he had recently gotten his clerkship and had moved out at that point to Virginia. And I just sent him an email, and I told him that I appreciated his story and asked him if he'd like to meet for a drink, and he said yes. And so we met, and we quickly became friends, and we stayed in touch. And then a few years later, I was clerking, and in fact, I clerked for 2 judges, both on the 6th Circuit Court of Appeals in Louisville, Kentucky. And as I was wrapping up my clerkship, we had discussed opportunities to work together, and we began working together. And it's been fabulous.
So interesting. You say that you clerked for 2 6th Circuit Court of Appeals judges. In what way did the experience that you received as a clerk for appellate court judges influence or help you prepare for the career that you're leading now?
Oh, I think that it was absolutely instrumental. There's no way that I would be able to provide the value that I provide on the appellate teams I've been a part of without the clerkship experiences. And I think both of them were instrumental in the first. I clerked for a judge who had been on the bench for 30 years, and he was very knowledgeable. He had protocols and procedures, and he had experience that he could draw on when he saw a case. He could recall, look at this case from 1988, or look at this case from 1995. And so that was very useful. And then I clerked for a second judge who was brand new, and the experience of helping him figure out what should be the protocols and procedures and how to approach a case was very useful. And so all of that together helped me build a strategy for approaching a case. And I think how I approached cases to decide them, or not to decide them, but to decide how to write my memos that I would write when I was clerking, inform how I approach a case now, and how I do the research, how I review usually the lower court's decisions and rulings, and how I articulate arguments to produce favorable results.
So for those in our audience who are not familiar with the judicial system, we have three tiers of courts really in the federal system, which is the district court judge, and those are the people that are determining the issues of fact. Then you have the circuit court judges, which are where you worked, Kyle, and that is really, you described it as the lower court. So it's really assessing whether that lower court complied with due process, or am I correct in that?
Yeah, well, right. So due process can be part of it. Right. The trial courts where folks go to and usually have a jury trial or where they make a guilty plea to the judge, those are called district courts, like you said. And when you're sitting on a court of appeals, the judges there, they consider themselves lower than the Supreme Court, but they use the term lower court at their vantage point to refer to the trial court. And it's typically the role of an appellate judge is to find errors or abuses of discretion that were made by the trial court, and then determine whether those errors, if they exist, warrant reversing the outcome and either sending it back for a new trial, or in some cases simply reversing the verdict and ending it there.
So everybody has, now correct me if I'm wrong, or I should probably just ask you the question. My understanding is that every individual has a right to go to that intermediary court, the circuit court, but not everybody has a right to go to the highest court in the country, which is the Supreme Court. Could you explain if I'm accurate in that, and what the process would be to advance if you didn't get the outcome you wanted at the circuit court level?
Yeah, that's right. Almost everybody has the right to go to the circuit court. Certainly everybody who has just had a jury trial has the right to appeal to the circuit court. In some cases, if you've entered a guilty plea, you may have waived your right to an appeal. And absent some reasons why you should be able to withdraw that guilty plea, you then wouldn't be able to appeal. And there are some other claims related to immigration, et cetera, that are not always appealable at all. But for the most part, you have this right to appeal to the circuit court. But with the Supreme Court, essentially no one has the right to petition for review in the Supreme Court. There are a handful of cases some relating to elections or voting or whatnot that do essentially have a mandatory review in the Supreme Court, but those are special and fairly uncommon. Instead, you have to file a petition for a writ of certiorari, and those are not very frequently granted. It's typically a few dozen cases a year that are actually heard, argued, somewhere in the neighborhood of 70 or 80 at most these days. And there are other cases that are decided on the papers by the Supreme Court, but it's very uncommon to receive hearing, let alone win a Supreme Court case.
So given your extensive experience in reviewing lower court rulings, both as a clerk and in your career, I take it that your area of expertise, or the place where you enjoy working the most, is on appeals. Is that right?
Absolutely, 100%.
And what options do they have after they've had a verdict of guilt and they want to say, oh, I'm not happy with the justice that I received, I want to pursue something else? What options do they have?
Yeah. Well, it's really, I think there's like a 5-part approach here. So first, as soon as the jury returns the guilty verdict, you file what's called a Rule 29 motion, or a motion for a judgment of acquittal, where you're asking the judge to say, those jurors could not reasonably have returned a guilty verdict. Judge, as a matter of law, I want you to reverse that verdict. And that's very uncommon for the judge to do that, but that is sometimes successful. You may also ask your lawyer to file a Rule 33 motion, which is a motion for a new trial. The standard for winning that is a little less onerous than what I mentioned about the Rule 29 motion. Essentially, if the judge, as a 13th juror, would have come out the other way and found you not guilty, then the judge can order a new trial. Of course, you have to go through a new trial. So that's item 2. Item 3 that we sometimes will help with is a motion for bond or continued release pending appeal. And that's not an attack on the conviction, but it's certainly part of a package that we would propose that someone consider. Is they file their motions for new trial. They also file a motion for continued release if they're out on bond already, pending appeal, so that while their appeal is going on, which can be a year or 2 or more, they get to enjoy their freedom and remain at home. And then comes the appeal. And so the appeal is primarily done on the paper, but there is an argument almost always after a jury trial. The appeal will carry an argument. And then if that's not successful, then after the appeal, there's sort of part 5 would be a handful of final attempts. And so that would include, in the Court of Appeals, you would ask for rehearing by the same panel that decides your appeal. You would ask for rehearing en banc by the full Court of Appeals, by all of the judges on that court. You would file a petition for certiorari for review by the Supreme Court, if that's appropriate. And then you would try post-conviction review in the district court, which is a whole separate set of filings. And so all of that could come after if the appeal is unsuccessful.
So when you were speaking about the Rule 29 and the Rule 33, I think it's important for our audience to understand these are for people that went to trial, people that pleaded guilty or accepted a plea agreement. Would they have access to those Rule 29s? No. Okay. So that's an important verdict. And you'd also mention an en banc hearing, which is really interesting. So in the circuit court, there are only 3 judges, it's my understanding, that hear the appeal. What is the difference between this 3-judge panel that hears the appeal as contrast that with the en banc hearing? Right.
So the general rule is that a 3-judge panel hears the appeal, and the 3-judge panels are drawn at random to decide 1 or 2 days worth of cases, essentially. The panels of judges are constrained to follow precedent. Whatever the previous rulings of the Court of Appeals say on a particular issue of law, the panel must follow. Now, sometimes you'll have a prior precedent that the panel, perhaps expresses that they disagree with, or there might be a prior precedent that other judges who are not on this panel don't want to see applied. For any number of reasons, after a panel circulates a published opinion in a case and before it's final, any of the judges on the Court of Appeals can request a vote of the other judges to decide whether to go ahead with an en banc hearing where it depends on the court, all 10, 15, 16 judges will hear the case and just do a rehearing. And if a majority of the active judges on the court agree to rehear the case en banc, then they'll simply vacate the panel's ruling and they'll have a new argument, and then whatever a majority of the en banc court decides to do becomes the outcome of the case.
So Kyle, thank you so much for giving us that backstory on appeals and the importance of appeals. But let's talk about somebody who may really be pre-conviction. He may be pre-charge. He may be he hasn't even had a finding of guilt yet, but he understands the possibility as it exists. Does it make sense for somebody at that early stage to retain a law firm like yours to be talking about sentencing or potential appellate issues? And if so, how does that process work?
Well, it certainly can make sense to have a second set of eyes on filings. I think we worked with a lot of trial lawyers, and they're great trial lawyers. And it's as a necessity of these great trial lawyers become very well versed in the facts and details of the case. And that's super important in being able to communicate with the judge and potentially a jury and with the prosecution about the case. But I think where we have added value is just as a second set of eyes to ensure that one of any issues for appeal are being preserved and are being argued in an effective way in the district court, so that when the Court of Appeals reviews the transcript, reviews the record, they will fairly confront the issue in the way we'd like them to.
And no, so that's very helpful. That people should be thinking in terms of always, the strategies or the seeds that they can plant today for almost like an insurance policy in the sense that if somebody does have the resources, it probably makes sense to bring not only a second set of eyes, but a set of eyes that specializes in appeals. So maybe are there seeds that as part of a strategy that if this doesn't work out this way, we've got something to look forward to this way. Does that make sense, or is that a waste of time?
No, I think again it obviously is time and money, and it can make sense when there's reason to suspect that an appeal is likely, and in those cases, again, I think the primary benefit of having an appellate shop helping out with the trial team would be to review the paper filings, not to attend every hearing and status conference, etc., but to review the filings that are going in the docket, and potentially other pre-trial drafts, etc. And that way also the appellate team can have a head start and get a sense of the government's hand and how to frame and brief the issues when it comes time for an appeal. One of the challenges with an appeal is often the timing. The trial can go on for years with all the pre-indictment and indictment process, and then everything else, but often the appeal is initially due within months of the jury verdict or sentencing, and that can all happen very quickly.
As I mentioned, a lot of people that are viewing the Prison Professors program are in jail and prison, and they may need to hear a little guidance from you, to the extent that you're able to provide it, with regard to administrative remedy and what role that can play in a person's potential litigation going forward. What is the administrative remedy process in jails and prisons?
Well, typically, I think you're referring to grievances, right? When someone has usually a problem with their conditions of confinement, they would need to pursue the grievance procedure all the way to its end and make sure that they're reading the rules on how to appeal those determinations. And if you don't follow those procedures fully, then you might not have the right to bring your challenge to court. And so typically before you could, bring what's called a 2241 motion or petition in a federal court to challenge your, perhaps the calculation of your sentence or something like that, your award of good time credit, you would first need to follow the administrative procedures. We also see that come up in the context of the First Step Act. I don't know if you wanted to talk about that.
Sure. I'd love, that is one of the questions that I wanted to talk about, but also even just differentiating between the structural, I think, mechanism of a 2241 versus a 2255.
Sure. Well, and I will say we do more with the 2255. That the 2250. You hear these numbers, and they're not like incantations, like you just speak them and something happens, right? But they're the section code, the section number in the U.S. code, and so section 2241, as I mentioned, is for more challenging the execution of your sentence, and whether it's conditions of confinement or calculation of a sentence, for more procedural matters like that. 2255s are your standard habeas corpus remedy for a federal prisoner who is challenging something like ineffective assistance of counsel. That's probably the most common basis for a 2255. It can also be used for newly discovered evidence and a few other things, but often what you may hear is someone who's upset that their lawyer didn't make a certain argument when they went to trial or even on appeal. And so the 2255, you have 1 year from the finality of your conviction to file this 2255. That goes to the same judge that sentenced you. And if the judge denies your requested relief, which typically you would be requesting a new trial or something like that, then you would ask that judge for a certificate of appealability so that you could then appeal his denial or her denial of your 2255 back up to the circuit court. So it's almost like a second bite at the apple, but typically it's for just a few different matters like ineffective assistance of counsel, claims that your lawyer reasonably should have made an argument or done something for you that he didn't do.
And so you'd mentioned this timeline of 1 year from the time a case is final. When does the court consider a case has become final?
I think we'll probably take the L on that one because that's probably a little more complicated than I want to answer on this.
Okay.
So, sorry, I could have probably given you a good answer.
No, that's all right.
Yep.
How about a second question?
Sure.
Sometimes when the person is out of time with regard to that 1 year time limit, we've heard of some esoteric writs like the writ of coram nobis. Could you give us any insight on what a writ like that is or what it does?
Yeah, I think what comes to mind, this is something that you don't see too often, is habeas corpus only applies to someone who is in custody. So a writ of coram nobis, I think technically, can be filed by someone who is out of custody. And it's another way to have a petition go before your sentencing court. I believe this all goes back to the All Writs Act and the Judiciary Act of 1789, that it allows you to file more or less any writ at common law. But that's not something we see too much of.
When I was in prison, a lot of times people would look for any type of vehicle that would allow them to give the jurisdiction back to a judge so that they could hear it. Because if otherwise they're just not in the game, and they were trying anything they could. But today you mentioned the First Step Act, and today there are a little bit more opportunities maybe to access the court, particularly in light of this Section 3582 with compassionate release. Could you give us a little bit of insight on how that motion works and why that motion might be of interest to people in prison today?
Absolutely. That's something that we've had great success with, especially recently. And it's a fabulous provision that allows judges to really take a second look at sentences that might have been too harsh. As long as the judge finds extraordinary and compelling circumstances that warrant a sentence reduction, the judge can reduce the sentence. I will say the term compassionate release gives the impression that it's always going to result in release. That's not necessarily true. It's a provision that allows for a sentence reduction. It has been used with great success to result in the release of folks who have already served a good deal of time, but at least theoretically a judge could use it to cut, say, a 20-year sentence into 10 or something like that. I think the important point is there are administrative remedies that someone who wishes to pursue relief under the First Step Act must follow, and there's ongoing litigation now about how precise one has to be. But essentially, if someone wants to pursue compassionate release or a sentence reduction in their sentencing court, they first have to file the administrative remedy with the Bureau of Prisons. And if 30 days from filing their request goes by with no response, they can then go to court and file a motion for sentence reduction there. But if the warden denies the request, etc., they have to include a copy of that with their motion in court. So if you go straight to court first, then the court will likely say that you have failed to exhaust your administrative remedies, and that's just going to cause ongoing delay.
So in today's environment where we have this pandemic going on around the country and judges have been intervening in some jurisdictions, at least that's my understanding, does a person, even during the COVID era, that if they want to bring it to the court, do they also have to go through administrative remedy, or do they not?
Absolutely. No, the statute the great development in the statute was allowing the prisoner to go to court, but only after they go through the administrative remedy. And so it's essentially a 30-day waiting period. If you get no response or an unfavorable response after 30 days from the Bureau of Prisons, then you go to court at that point.
I think it's always difficult to get a different outcome. Your team has been really successful in helping people get different outcomes through various channels, whether it's through habeas petitions or appellate petitions, or as you said now, in light of the First Step Act with these new remedies. But people who have lost at every stage in the proceedings that have very long sentences, there's another option that is called executive clemency. Could you help our audience understand a little bit more about what are the different types of executive clemency?
Right. So the two primary options are commutation of a sentence or a pardon. Commutation of a sentence typically involves lowering a sentence it can be from death to life, or it can be from a term of years to a lower term of years, which can result in release if the term of years that it's lowered to is time served. And then the other option is a full pardon, which of course would also entail release, but also would include full restoration of rights, such as the right to own firearms and whatnot. There are a few different avenues, I suppose. Now, this is going to be dependent on the administration. So if someone is watching this and there's a different administration in office than there is today in September 2020, everything could change. But under the current administration, there are sort of three avenues of executive clemency. One is the standard. You go through the office of the pardon attorney, who would then make recommendations that that are acted on. That's not being used much, if at all, right now. Two is the president has an advisory board that gathers and makes recommendations, and that has been used and acted upon. And then three is the president himself has full power, unfettered authority to grant pardons or commutations for any reason, but only for federal inmates, we should say. And then all of this executive clemency that I've been referring to applies strictly to federal crimes. If someone is in the state system, they would have to go through their state, presumably governor's office or board of pardons and paroles to pursue clemency there.
So it's always the chief executive officer of the jurisdiction.
The jurisdiction, sure. That's right.
Yeah, that allows it. So in federal, it would be the president. In the state of California, it would be the governor. And in some places, it's my understanding that they actually have pardon boards, board of pardon and paroles, which is almost like a parole board that can review and assess. If a person is going into the system and wants to be thinking about that, what steps might he take to make your job easier when it comes to hire the firm of Hopwood and Singhal to say, oh, I'm interested in executive clemency, whether it's a commutation or a pardon, and I'd love for you guys to represent me. How could that person become a great client for you?
I think the most important thing is to present all the facts and really have factual documentation on paper that shows candor right up front, because what's difficult is if you hire a lawyer, whoever it is, and you only tell them part of the story, and then sometime down the road the rest of the story comes out, and it's just better for everyone to have whatever the full story is, to have that up front. And so whether it's all records from police reports, there's obviously stuff that can be obtained from public dockets like indictments, but the police reports, other law enforcement records that maybe the defendant has access to that aren't as easily available to us or to whoever the lawyers are, having all of that, victim statements, just everything that could be relevant up front, and that will enable the lawyers to take a look at how to present the case candidly and accurately. It's not it's not typically to the prisoner's advantage to continue fighting guilt at that point, but rather simply to explain, have the facts up front, put them on the table, and then decide based on that what the best avenue for relief is.
So that's kind of a mechanical, formulaic strategy. What about the more, rather than focusing on that static, because that he can't change the fact that he did some crimes, are there mitigation steps that might really make a case more likely to advance with the process, or make it easier for a law firm to argue more persuasively on why an act of mercy is worthy in this case?
Well, certainly behavior during confinement is crucial. I mean, excellent behavior and taking as many steps as possible to show rehabilitation, to show education and helping others, and getting recommendations. So it was a first step case, but recently we had a case where someone's 213-year sentence was reduced to 20, and having recommendations of wardens, I think, was crucial to that outcome. So anything someone can do, I think you make a great point, that's dynamic as opposed to the static factors of their conviction, to show that they, sort of an odd phrase, but deserve mercy, but to show that I think what you'd like to do is persuade someone in a decision-making position that if they release the prisoner, that the prisoner's not going to get out and do some bad act that then they'll regret the pardon or whatever it is, right? And I think we've heard the president say things like that, like, all right, go and do good things now that you have your liberty. I think there is a general fear among those who give pardons or clemency that what if I give a pardon to someone who then goes out and commits some heinous act, right?
So as somebody who did 26 years in prison, and I'm communicating to people in jail and prison, I asked that question because I want you, as a viewer of the Prison Professors Program, to be thinking about that today. It's not easy to do. It's something that I had to be thinking about at the start of a journey, is saying, how do I want to emerge from this? And I know it's difficult while you're living in prison or you're in jail and you've got influences around you that are telling you how to adjust to confinement. But if you want a different outcome, if you want a lawyer to take your case and argue in the most effective way to get you the relief that you want, you've got to do your work to try and make it easier through your mitigation of it. Avoid disciplinary infractions, pursue an education, build a record that shows that you are worthy of people believing in you, build a strong support system. All of those are factors that led to relief for guys like Adam Klossum, who they represented and got that sentence down. And you'll hear Adam's story on this program. But I want you to be thinking about yourself. Yesterday, I got a call from a guy in prison that's serving a life sentence, and he's been in jail for 30 years. But the key is he's trying now to reform his life. It's not an overnight challenge to overcome things of that sort. It's a matter of sowing seeds early, nurturing it, and over a period of time, building that support. And I really want to thank you, Kyle, for spending time with us and helping us understand the ways that you help people, and certainly getting a reduction of a 200+ year sentence down to 20 years is a phenomenal outcome. It's something that really is a community effort where the inmate has to help and you have to help. And then you have to, of course, have the right judge or chief executive that's going to give you that relief. But I'd like to ask you one final question, if I could, about Second Amendment matters. You'd mentioned that earlier in your thing, and I have a personal relationship with a fellow who got his Second Amendment rights despite having a felony. Is there any insight that you can provide us with how somebody might go about getting Second Amendment rights if they have, say, a white collar crime?
That's honestly not my area of expertise, Michael, so we may wish to cut that also if you want to.
Yeah, that's fine. Okay.
Give me a different final question if you want to reverse.
Let me try another final question then. Well, no, I'll just close out with. So again, Kyle, I just want to thank you very much for sharing your story or sharing your area of expertise with our audience. And I really want to recommend Kyle. I know him personally. I've met him personally. I've also seen the great outcome that he and his team have gotten for another friend of mine, and not only Adam Klossum, who was serving time in prison, but an individual who has just faced a prosecution. So I will personally vouch for him, and I hope that you will, if you're looking for appellate counsel or habeas counsel, you will consider the firm of Hopwood Singhal in Washington, D.C. I'm going to leave the last words with you, Kyle, and say, is there anything that you might want to express to our audience? And our audience are people who are either going into the prison system or people who are in prison.
Well, I'll say two things, Michael. First, your story is inspiring, and it's just great to be here and be a part of your programming. So thanks again for having me. And for those who are watching, just never lose hope. No matter, you don't know what the future holds. You don't know what changes could come in the law. And if Adam Clausen had a 213-year sentence and didn't lose the hope that he could help people and lead a meaningful life every day, then keep the hope. There's good you can do with opportunities that come every single day, and don't let them go to waste.
So in the show notes below, we will have, of course, links to the Hopwood Singhal law firm. I will provide information that what I've learned from them. So if you have not, if you're watching this in the community and you have access to YouTube, I do hope that you will subscribe to the channel. And if you have needs of an appellate attorney, if you're facing a sentencing hearing, it might make sense for you to send an email to speak with Kyle and see if there's some service that he can provide for you. Thank you.
All right. Thanks, Michael. Take care.